Hi, I'm Professor Mark Grabowski, and this short video lecture will talk about challenges to Internet lawmaking, specifically technical difficulties at the Supreme Court. Let me explain. If you're in America and not yet acquainted with cell phones, computers, and the Internet, you must have spent the past couple decades under a rock, or be a member of the U.S. Supreme Court. Supreme Court justices lately have displayed a startling level of ignorance about computing and communication methods that many Americans take for granted. Yet, as members of the nation's highest court, they're increasingly setting legal precedents about these very technologies. Consider some of these recent examples. At an oral argument, Chief Justice John Roberts, who reportedly drafts his opinions with pen and paper instead of a keyboard, compared a software program being executed on a computer with a typewriter typing out words on a piece of paper. He also referred to internet search engines as, quote, a search station. In another oral argument, Justice Anthony Kennedy wondered what would happen if a text message were sent to someone at the same time he was communicating with someone else. He asked, "Does he have a voicemail saying that your call is very important to us? We'll get back to you?" This elicited laughter from those in attendance. The justice's tech cluelessness was not just an irrelevant oops, but actually incredibly important in the two cases. One involved applying intellectual property law, and the other involved interpreting the privacy protections of the Fourth Amendment. It gets worse. During a recent congressional subcommittee meeting, Justice Antonin Scalia admitted he didn't know much about the popular social networking service Twitter.
What happened? Have either of y'all ever considered tweeting or twitting? I don't even know what it is. To tell you the truth, I've heard it talked about, but my wife calls me Mr. Clueless. I don't know what tweeting.
More recently, in a candid 2013 interview, Justice Elena Kagan admitted she and her fellow Supreme Court justices aren't very tech-savvy and still communicate with each other the same way they did when she was a clerk in 1987, with paper memos. These are just a few examples. No wonder the court is often criticized for being out of touch with ordinary people. Technology touches virtually every aspect of our lives and often is affected by laws. The Supreme Court's lack of tech familiarity has legal scholars concerned. With the Federal Communications Commission now aggressively attempting to regulate the Internet, with cyberbullying testing the limits of free speech in schools, and with bloggers seeking the same rights as journalists, the court will invariably be called upon to make judgments that relate to technology. It's crucial for our most important decision makers to have at least a rudimentary understanding of technologies most Americans can't imagine living without. If the court can't grasp how business inventions have changed since the Industrial Revolution, or how communication methods have changed since Alexander Graham Bell, then they might make decisions that misapply the law due to a misunderstanding of the facts about technology. In order to modernize the Supreme Court, a variety of measures could be taken. One idea is that future appointees should be vetted for their tech savvy during Senate confirmation hearings. Another proposal is to impose a mandatory retirement age on Supreme Court justices instead of allowing them to enjoy lifetime appointments. The average age on the Supreme Court is about 70 years old. In the European Union, judges on the highest court do not have lifetime appointments. Or the United States could follow Japan's lead and form a special court to address cases involving complicated technological matters. Finally, the Supreme Court could hire an impartial expert to consult on tricky cases involving technology and the Internet. In the meantime, current court members need to take the initiative to change themselves. While technology has forced workers in many industries to retool or retire, justices can't be required to change because they enjoy lifelong appointments. Perhaps they can follow the lead of Justice Stephen Breyer, who said he learned about Twitter by sitting down with his son for a lesson.
My personal experience with that, I didn't know how it worked. And then remember when they had that disturbance in Iran?
That's true.
Well, for my son said, go look at this. And oh my goodness. I mean, there were some Twitters, I call them, but there were people there with photographs as it went on. And I sat there for 2 hours, absolutely hypnotized. And I thought, my goodness, this is now, for better or for worse, I think maybe in many respects for better. In that instance, certainly. It's not the same world. And it's instant. And people react instantly. And there we are. I just say there's quite a difference.
Breyer obviously has some catching up to do on the digital age, but it's a start, and it's better than being complacent with being clueless. As Breyer noted about the internet,
it's not something that's going to go away.
Once again, this has been Professor Mark Grabowski. If you're in my internet law course and have questions, please shoot me an email at mgrabowski@adelphi.edu. Thanks for watching.